Hi everyone, my name is Shazia Khan and this is the assignment discussion session for contract law, the principles of contract law, and it's the final session before you start doing your assignments. So before I go into the assignment discussion session, I'm just going to give you an overview of what we've done in the last 4 learning outcomes. So in the first learning outcome was learning outcome 1, which was to understand the principles, requirements of binding agreement. We looked at what a contract is. We looked at contract agreement obligations, enforcement under the law. We looked at identifying parties to a contract. We looked at elements of what a contract is, what the requirements are of a contract, such as offer, acceptance, consideration, intention to create legal relations. We also looked at capacity and certainty in learning outcome 1, legality of purpose, formalities, and examples of binding agreements. We then went on to look at the definition of a contract and key elements of a contract, which are agreement, obligations, enforcement, consideration, legality, capacity, and intention. We also looked at explanation of key aspects of a contract. We went on to look at how to make a contract, make a legally binding offer and acceptance. We looked at identifying parties to a contract, and making a legally binding offer. We looked at communicating an offer, so verbal communication, written communication, digital communication. We looked at acceptance of an offer, unconditional communication, method of acceptance. We looked at how offer and acceptance may be withdrawn with reference to cases like Carlisle and Carbolic Smokeball, Pharmaceutical of Society of Great Britain and Boots, and Adam and Lisley. We also looked at accepting an offer, so communication of acceptance, method of acceptance. We looked at invitation to treat and offer and what is the difference between them with reference to the Pharmaceutical Society of Great Britain and Boots case. We also looked at that postal rule and the electronic acceptance and the postal rule. We looked at revocation of an offer, withdrawing acceptance. We looked at how to enforce a contract. We looked at counter offer and destroying the original offer. And we looked at cases such as hide and wrench. We looked at the privity of a contract in learning outcome 1 and consideration, promissory estoppel, intention to create legal relations, and honour clauses in business relations. We also looked at explaining the terms invitation to treat and the intention to create legal relations with reference to cases such as Partridge and Crinington and Pharmaceutical Society of Boots as well. We looked at elements of comparison of invitation to treat and intention to create legal relations. And we looked at elements of business and commercial agreements. So that was learning outcome 1. We then went on to look at learning outcome 2, which is to understand the principal contents of a contract. Here we looked at what the elements that form a valid contract. We looked at the terms of the contract. We looked at the principal contents of a contract, terms of a contract, express, implied, exclusion clauses, conditions, warranties, inanimate terms, consideration, performance, termination clauses, dispute resolution, and governing the law. We also looked at conditions, warranties, and inanimate terms with reference to cases such as Hong Kong Fire Shipping Company, Kowalski case 1962, and Dunlop and Selfridge 1915. We looked at statutory express terms within the Unfair Contract Terms Act 1977 and the Consumer Rights Act 2015. We looked at statutory governance of exclusion clauses and examples of that. We looked at the Unfair Contract Terms Act in more detail, so the key provisions, key cases like Smith and Eric S. Bush 1990. We also looked at the Consumer Rights Act 2015 with reference to cases like Office of Fair Trading and ATHE PLC. We also looked at elements of how a representation is different from a term, so the key features. We looked at factors courts consider in learning outcome 2 in determining representation against a term and looked at cases such as Bannerman and White, 1861, and Dick Bentley Productions Limited and Harold Smith Motors Limited, 1965. We looked at terms implied by custom, trade, and usage, and we went on to look at how terms may be implied in common law, terms implied in fact, and also terms implied in law, and limitations on this, and how terms can be incorporated into a contract. So we looked at implied terms incorporated by law, incorporated by reference, and exclusion clauses. We also looked at contract conditions and warranties, and discharge remaining contractual duties on breaches. And we also looked at the validity of exclusion clauses and limitation clauses. We also looked at in learning outcome 2 at operation of exclusion and limitation clauses in businesses, statutory controls on exclusion clauses, and we also looked at the evaluation of validity. We then went on to learning outcome 3, which was looking at understanding principal factors that may vitiate a contract. We looked at the understanding the principal factors that vitiate a contract. We looked at mistake, misrepresentation, duress, undue influence, and illegality. We looked at cases such as Derry and Peake for misrepresentation, Headley and Bryan and Heller for misrepresentation, the types of misrepresentation, and we looked at duress and undue influence and illegality with reference to cases like Lloyds Bank and Bundy, 1975. We looked at illegality as well in regards to that. And case like Pearson and Brooks, 1866. We went on to look at outlining various types of contractual mistakes, common mistake, mutual mistake, and unilateral mistake. We looked at capacity to enter contractual relationships, so minors' contractual capacity. We looked at mental incapacity and intoxication. We looked at elements of different types of misrepresentation and mistakes, so fraudulent misrepresentation, negligent misrepresentation, innocent misrepresentation. We looked at the Misrepresentation Act 1967 and governs remedies like rescission and damages. We looked at types of mistakes, so common mistake, mutual mistake, and unilateral mistake. We went on to look at how a contract can be discharged, methods of discharge by performance, by agreement, discharge by frustration, by breach, and also we looked at how lack of capacity, illegality, and public policy may void a contract. We looked at lack of capacity, illegality, public policy, effects of void contracts. And then we looked at how undue influence and duress may void a contract, and look at Atlas Express cases, again, Lloyds Bank and Bundy. We looked at undue influence in family and professional relationships, and we looked at effect on contract, and we looked at the elements of the nature, examples and key cases for all of the aspects within learning outcome 3. So learning outcome 4, the final learning outcome, we looked at understanding how a contract may be breached. Here we looked at breach of contract, understanding how a contract can be breached, types of breach. We looked at actual anticipatory breach. We looked at with reference to cases like Poussard, Spears and Pond, 1876, and Hostia and de la Torre, 1853. We looked at breach of terms, such as a condition, warranty, inanimate term. We looked at damages and types of damages, and we also looked at Hadley and Baxendale case. We looked at specific performance, injunction, rescission, quantum merit, and we looked at key considerations in breach of contract. And we also looked at elements of the effect on breach on a contract. We looked at anticipatory breach, repudiatory breach, effect of breach on remaining contractual duties, and we also looked at the role of equitable remedies in contractual breach, the types of remedies and requirements for accessing equitable remedies. We looked at the types of contract breach, including anticipatory and repudiatory breach. We then went on to look at effect of innocent parties' obligations on breaches. We looked at the meaning of damages in relation to contracts such as compensatory, consequential, punitive, liquidated, and punitive damages, and how they are calculated, and factors that affect damages, causation, foreseeability, mitigation, and remedies available for breach of contract, which we've gone through. So we looked at each of them with reference to cases and case examples to identify that. So now we're going to go on to the assignment discussion. Just pull up the assignment discussion. So the assignment discussion, the assignment brief is available on Moodle for you to have a look at in your own time. And I will show you the assignment brief as well. So the unit aim is to cover what is meant by contract through offer, acceptance, and invitation to treat. Students will be introduced to key terms and how these form part of a contract in both express terms and implied terms. The unit will also cover the principles of how contracts can end, including breaching and remedies for the breach. So again, the learning outcomes that we've done on this unit are learning outcome 1, which is to understand the principle of requirements of a binding agreement. Learning outcome 2, to understand the principal contents of a contract. Learning outcome 3, to understand the principal factors that may vitiate a contract. And learning outcome 4, to understand how a contract may be breached. Assignment declaration, and this is really important part of any assignment that you have to do, and I'll just increase the size so you've got a little bit of idea. You have to sign this declaration to make sure that the work that you are submitting is your own work and the originality of the work is your work. So you have to confirm that you've read the policy in place on plagiarism and malpractice, and you have read the contents of the policy. So you will be ticking that and signing that. So you can see there that I confirm that assignment is my own work and I've read and understood the college's guidance on plagiarism. You've also clearly referenced in both text and the bibliography or references all sources you've used in the work, fully referenced including page numbers and inverted commas for all text quoted, provided the sources of all tables, figures, etc. that are my own work, not made use of work of any student, so you haven't colluded with any other student's work or copied any other student's work, and the work that you've submitted is your own work. This is really, really important because you need to identify that the work that you've committed is not being copied, not bought, not saw or used any professional agencies to produce the work. So any sort of agencies that would plagiarize the work for you or do the work for you or paid anyone. I understand that any false claim in respect of this will result in disciplinary action in accordance with the college regulations. Because you've read the regulations, you've signed the document, you've done a declaration to say you haven't copied anyone's work, then that is okay. But if you make sure you are moving away from that and you are referencing your work, make sure that you are, when you are doing your work is referenced, but also your work is your own work. So what information needs to go on the assignment? So you need your name, registration number, your tutor's name, your word count for this assignment is 2,500, and the date of submission. So you have 2 weeks after we've done this session to submit the assignment, okay? So you've got that time to submit it. Make sure you're doing and putting all this information on it. The unit level, which in this case, level 3 principles of contract law. Plagiarism and collusion, and we'll keep going back to this to reiterate this to you all the time. Students must submit and complete work that is their own. Plagiarism is presenting the thoughts, ideas, and words of another person as if it were their own, as if it was your own work. Collusion may occur when students' assignments are very similar and in some cases identical to that of another fellow. This also amongst to plagiarism. Plagiarism is taken very seriously, and the student is strongly recommended to refer to the academic misconduct policy, which is available on Moodle for you, which is the VLE. Start of the assignment, you need to include the following, which is a table of contents. Font size needs to be 12, and the 1.5 line spacing. Page numbers need to be inserted, and you need to make sure that you are not using Google and doing your work on Google. You need to be using Microsoft Word format, and the link is there. If you do not have it, you can download it free on there, and that link will help you do your work in Microsoft Office rather than using Google, because it will not be accepted and it could not be marked on Google. Okay, so you need to make sure your work is on Microsoft Word format for the assessor to mark it properly. You will have an introduction, and word count will be 2,500 words. And make sure you are putting assessment criteria in the headings. So make sure it's a professional piece of work and it's not just copy and pasted. And again, using AI, avoid using AI because the tolerance will come up and it will be a form of plagiarism. It's not, it is plagiarism. So general information, the taught part of this unit will be delivered at UK Versity Online. There are a number of texts related to this unit to be found in the VLE LMS handbooks and briefing sheets, and your assignment briefs will be provided in individual sessions where appropriate, along with links to the relevant unit information, which is on Moodle, where you can find all your course material and your assignment briefs on there, all your course materials on there, any sort of additional reading, any sort of policies in place that you need to go on, they are all on there for you to read on in your own time. So let's go into the assignment brief. So it's task 1 of 2. Task 1 of 2, assess AC 1.1 to 1.5 and AC 2.1 to 2.6. So you need to look at, firstly, understanding the requirements of a binding agreement, and secondly, analyze the contents of a contract. So assignment brief and guidance. So you are working with a friend who is about to start a new business. He wants to circulate some information to his staff around contract law so that they have more knowledge in this area. He's hoping that by doing this, it will make it easier for staff to develop and maintain relationships with clients. He would like you to produce a small guidance on the basics of contract law. So what he wants you to do is he wants you to include what the term contract means. So the definition of what the term contract means. So he needs you to look at that. So for that, you would go into learning outcome 1 and look at the elements of a contract and what contract law is and what it means. He wants you to secondly look at, so these are 5 parts in part 1, task 1. So the first one, do not change the wording, use that as a heading and answer under that, okay? Second bit is an overview of an offer and acceptance. So here you will be looking at what an offer is, what acceptance is, and key features and characteristics of an offer and acceptance and what they contain. So you need to look at them in the second part of it. The third part of it is how contracts can be enforced. So you need to be looking at how contracts can be enforced, the key elements of a contract, and how to make a legally binding contract. Okay, so you need to identify elements of that, and that would be learning outcome 1 and 2 as well. How contracts can be breached is the second part of it, and that would look at how contracts can be breached. So you would look at elements of that in learning outcome 1 and 2, how contracts can be breached, and what remedies are available, the 5th part. So do not change the wording of it. Make sure you have each one as a heading and then you write under each one, okay? So you put the answer, what remedies are available for breach of contract. So you'll be looking at the different remedies available for breach of contract. So if there's a breach of contract, what the remedies are available for that breach and why are these remedies available, and the key elements of these remedies available for that. Okay, so you need to identify each one. So for this, learners must show a knowledge and understanding of the subject area. So you need to be able to look at understanding what you are talking about. So there's 5 parts to task 1. You need to make sure that you know and you're answering that. Do not change the wording, have it each one and then have a heading under it. Provide references to relevant case law or legislation wherever appropriate. So if there's a need, put the legislation in and the cases. Be able to support answers and show evidence of wider reading appropriately here. So for learning, for the first one, the submission is in the form of a report. Okay, so it's in the form of a report for the first one. And in a written, sorry, it's in the first part is in the form of a report in written format. The recommended word count for that is 800 words, excluding diagrams, references, and appendices. So make sure you are sticking to the word count as well for them 5 parts you are doing. Learners are expected to adhere to the word count, and a 10% leeway either side of this range is permitted before the assessor is instructed to stop reading anything further. So you need to make sure that you are reading what it's been asked of you. So you've got 5 parts to the first one, and you need to make sure you do not change the wording, put each one in a heading and then write about each one. And it's 800 words and you have 10% flexibility. So maybe look at doing about maybe 180 words for each one to try and help you, 150 words, and try and, you know, support and answer the question. What the question is asking you, answer that. Okay, moving on to task 2 of 2. You've got AC 3.1 to 3.5, AC 4.1 to 4.5, and you've got to look at number 3, which is determine the factors that may vitiate a contract, and number 4, identify how a contract may be breached. So for that one, you are looking at, there's 2 parts to that. Part 1, here. Let's go to part 1. So here, Akil has come to you seeking some advice. He was talking to his friend Jade about him selling his Xbox console. They entered into an agreement for Jade to buy the Xbox. He remembers discussing games and accessories that he had with the console. He's worried that some of the things that he talked about may have formed part of a contract. Here you've got to advise Akil to the extent to which an oral negotiation and oral statements form part of a formal contract. And here you will be looking at the element of forming part of a contract. So look at oral negotiations, understanding the factors, and making sure that the contract is in line with the formal statements that have been made, and make sure there's no mistake, there's no misrepresentation, you know, and make sure from that statement that you are identifying that and looking at learning outcome 3 in regards to that and with reference to cases. Okay, here in the part 1, you must show knowledge and understanding of the subject area. You must provide provide references to any sort of cases or legislation, as we mentioned, and you must also be able to support your answers and show evidence of wider reading appropriate. Here you would need to, then we've got part 2 to this. So the English law is law protects those that does not have the capacity to enter into a contract. Write a report explaining how the English law manages to accomplish this. Okay, so here you'll be looking at learning outcome 4, and you'll be looking at elements of, you know, how a contract is breached, but also looking at how someone is protected if they have elements of, you know, the fact that they may be you know, issues of them being a minor, they may be intoxicated, you know, there may be, you know, elements of them having some form of intoxication, them being a minor, making sure that you are, you know, looking at the capacity to enter contractual relations in this, in part 2. So you need to make sure that you are able to identify that, you know, there are contractual relationships here, and you are able to look at that from that part perspective. And you are looking at minors who have the legal capacity. You look at minors' contractual capacity. You'd also look at mental incapacity and intoxication here as well. For part 2, so you would be looking at elements of that in regards to that. You'd be looking at contracts that become void. With reference to cases as well, you need to take into account how cases would you know, prevent this also. And you'd also look at lack of capacity, the key groups lacking that capacity, minors, with reference to cases, and mental incapacity, intoxicated people, you know, whether the contract is void or unavoidable. So you need to be looking at that, elements of that. making sure that you are identifying elements of the different type of lack of capacity in this. The English law protects those that does not have the capacity to enter into a contract. You need to write a report how the English law manages that, and that's looking at learning outcome 3 and bits of learning outcome 4, but more learning outcome 3 in regards to that. For this part 2 and part 1, learners must show knowledge and understanding of the subject area. You must provide references to relevant case law and legislation wherever appropriate, and you must be able to support your answers and show evidence of wider reading appropriately. The delivery and submission for part 1. So for part 1, you need to do it in the form of a document written in Word format, like I mentioned. The recommended word limit is 800 for part 1, which is excluding any diagrams, references, and appendices. Learners are expected to adhere to the word count. A 10% leeway either side of this range is permitted before the assessor is instructed to stop reading any further. So for part 1, it's 800. For part 2, the submission is the form of report again in a written Word document, and the recommended word limit is 700 words for part 2. Okay, so for part 1 is 800, for part 2 is 700 words, excluding any diagrams, references, and any sort of appendices as well. Learners are expected again to adhere to the word count. A 10% leeway either side of this range is permitted before the assessor is instructed to stop. So you need to make sure you are sticking to what the tasks are asking you. So you've got 5 parts in part 1, task 1, and in the second part you've got part 1 and part 2. Each part has its own word limit. So for the first part you're doing 800 words, for the second part is 700 words. Make sure you are looking at answering the question and not changing the wording. And then it's better for you to have each task under a heading and then answer that as what is expected of you. Okay. Again, you'll be needing to use case law here, academic resources and reliable sources. Any additional resources are available on Moodle for you. You would need a comprehensive Harvard-style referencing, which would need to be included at the end of your work. So you need to make sure you're using the Harvard system of referencing throughout, okay? End of the assignment, you need to make sure you do a conclusion, a reference list or a bibliography, and make sure you have an introduction at the start. So a basic introduction, okay? Some assignment guidance and support. So make sure you start with a basic small introduction and a conclusion. Make sure you are using Harvard system for referencing, which you can refer to online sites that may be able to help you, which I'll go through this at the end if we have time, and it looks at Neil's toolbox, and I'll just give you a little bit of an idea how you'd reference certain sources, maybe books, journals, articles, and how that would help you. If you're using diagrams, please make sure you reference them accordingly. Make sure you have a bibliography reference list and it's in alphabetical order, because we've realised, as I've realised when marking work or looking at where people put the references where they want to, they need to be in alphabetical and chronological order. Make sure you have a bibliography reference list, Try to use more examples when explaining certain concepts. For example, in this case, it may be theories, it may be statutes, laws, case law that you may need to make sure you use more examples. Make sure you are using the assessment criteria as a heading. Again, when we're going looking at task 1, you've got 5 parts to it. Make sure you're using each one and writing under each one. The task 2, you've got 2 parts to it. Make sure you are putting part 1, part 2, and then writing in the answer under each one so it's clear for the assessor to mark. You need to be referring to the indicative content all the time and checking the word count. Some important points, again, like I've just mentioned, proper headings and subheadings. Make sure the document looks presentable and professional, so you're not using bullet points or anything. Follow the numbering on the assignment presentation as against the assignment brief. Ensure at least 12 to 15 references. Referencing should be in the Harvard style of references. Keep a check on your word count. Keep checking your word count, and you have a 20% tolerance for AI as well. It needs to be below 20%. Your word limit for this is 2,500. Remember, there's a grading in the unit, which is a pass or a fail, a pass or a refer, and do not use AI software to write this assignment. There's only 20% tolerance allowed, else it will be considered malpractice. So as I'm going through, when I'm talking about plagiarism, make sure you are sticking to the percentage of tolerance on AI. It needs to be below, well below 20%. Please mention the grade you want to achieve in the unit if there's a grading unit. So in this case, it's a pass or a refer, so you do not need to put that in. So make sure you are following the numbering on the assignment and against the assignment brief as well. Useful tips: read the task carefully, and that's really important. We tend not to read the task carefully, so make sure you are reading the task carefully. Make sure you're focusing on the command verbs, and make sure you are, if it's asking you to explain, define, assess, make sure you are doing that properly and you're sticking to the command verbs and what is expected of you. Again, Harvard references system, make sure you are using that, and that is used in UK Varsity for all the work. Referencing needs to be Harvard system, date, style. For example, Slack, Johnston, Brandon Jones, 2011 in text. In the reference towards the end, it will be shown as the full thing. Minimum of 6 references: books, journals, article, websites. Give proper headings again, I'll reiterate that. Make sure your document is presentable and professional, and the word count is 2,500 for this task 1 and 2, with a 10% leeway. And plagiarism and tolerance initially below 20% on AI. So you need to make sure you try to avoid using AI for this. Plenary, you need to make sure you are not copying and pasting work, as it's plagiarism and would lead back to academic misconduct. And I'll keep reiterating that because it's so important. Make sure you reference all your sources. Make sure you check your grammar and spelling, because that's really important. Avoid using any sort of American style grammar. An example would be use the S instead of the Z for organization or anything like that. Make sure you check your grammar, spelling. Refer to ebooks and journals on Moodle for this unit, and there's so many additional resources that will be available for you on Moodle that you can refer to help you. If you're using UK Varsity slides, then reference will be as below: MDT 2022. Bibliography, the bibliography, it would say multidisciplinary teams, learning outcome 1, slide number 2 to 10, UK Varsity, published on 15th of January 2023. Again, any questions, please email learnerwork@ukvarsity.co.uk. And submission of the assignment is to be done on learnerwork@ukvarsity.co.uk. I just want to show you the assignment brief, okay? And it's available on Moodle for you and what it looks like. So you've got a little bit of an idea what it looks like. And everything from the assignment brief I've taken on, just put on the slides for you, which will be available. So all this is available on Moodle. This is the assignment brief that is available on Moodle, and this is what it looks like. So you have an idea of what it looks like. So it's got the unit reference number, the unit itself, unit level, credits, it's got the grading on, it's got the unit aims, and then it's got the learning outcomes 1, 2, 3, and 4, and then it goes into task 1, which is task 1 of learning outcome, and it tells you the assignment brief and the guidance it's expecting you to look at. So what a contract means, overview of acceptance and offer, how contract. So these are the 5 bits of task 1. You need to make sure you have that as a heading and right under it. Make sure you have that as a heading and right under it. And each one, so there's 5 parts to that, okay? And that is 800 words for each for all that 5 parts that you need to do, okay? In a form of a report in Word format. And I will always say this: use your referencing, stick to the guidance, it's so important. Task 2, again, which I've put on the slides for you. The first part is this scenario about a keel that you need to go through, and you need to advise a keel. And second part is the English law protects those who do not have capacity to enter into contract, write a report explaining English law. You need to be using throughout for all the task 1 and 2, you need to be having a knowledge of the area, you need to be using relevant case law and legislation to support your exam, you need to support your work, so you need to have case examples or other examples to support you, and you need to show that you've got wider reading. For part 2 is looking at the element of English law protects those who does not have the capacity to enter into contract, write a report how English law manages this. So you look at minors, intoxication, and you'd look at mental capacity with reference to cases like maybe for minors, it was the case of Nash and Inman. That you could look at in regards to, mental capacity. There's other cases that you could look at. So you need to make sure that you're able to identify elements of that and make sure that's clear. And that is part 1 and part 2. And for part 1, it's 800 words. For part 2, you need to do 700 words. Again, you need to be using case law. Again, you need to be making sure that you are referencing everything properly, making sure you are using the Harvard system of referencing. So this is the assignment brief. This is available on Moodle with the module spec and all the learning outcomes of learning outcome 1, 2, and 3, which are recorded sessions on there for you to refer to if you need to. Okay, so that this session is also recorded and it will be also available. What I'm going to do now is I'm just going to stop sharing this and show you Neil's toolbox, because I just need you to be able to understand Neil's toolbox so you've got a little bit of an idea of how it's used. So this is Neil's toolbox is a harvest. It's a generator, so it generates books for you or emails. It could be referencing a magazine. It could be referencing a book, a part of a book. It could be referencing a website. But we'll just go into first referencing a book, so you've got an idea of doing that. So let's put the book as Contract Law. The author, Hill. First name, K. The publisher, will put Peacock. The place of publish, will put London. And these are just an example for you, so you've got a little bit of an idea of how to use year of publication, maybe 2024. 2024, and the edition, first edition. So you press this thing called generate reference. When you've pressed that, it generates the reference for you. So can you see this? This is the reference. So it identifies the reference for you. It says Hill K 2024 Contract Law, London and Peacock, and it actually identifies all that for you and where the dots and commas are, so you can just copy and paste that and put that into your bibliography. So that will help you put that into your bibliography, and if you struggle with Harvard referencing, that will help you do it. You need to make sure that when you put it in your referencing in your bibliography at the end, you make sure that it's all in alphabetical order, the authors, and it's not where you just slot them in. Just put them all in alphabetical order. You can do copy and paste that. You can do the same for books. You can do the same for chapters of a book, websites, emails, journals, magazines, newspapers, films, radios. You could use this. And there's another one that you could use called Cite Me as well. But this would help you reference things. So because we use the Harvard system of referencing, this is a good generator that you could use. Let me just share the slides again. Just a minute. So just going back to the assignment discussion session, make sure you are sticking to what you are being asked, okay? It is asking you to do the work and stick to the task. Make sure if you've got any queries or anything, email learnerwork@ukvarsity.co.uk. Submission of the assignment is to be done on learnerwork@ukvarsity.go. You have 2 weeks to do it, so make sure you do it. Good luck with getting on with the assignment, and thank you for attending today's session.